Ladies and gentlemen, thanks so much for being with us today. My name is Barry Nicholsberg. I'm Chief Development Officer for Estate and Gift Planning at the Carter Center. Joining me here on the webinar is Mark Williams. He is an attorney and should be forgiven for that. And he is also Senior Associate Director in the Office of Estate and Gift Planning at the Carter Center. We'll be talking with you for the next hour. We promise no more. We start on time, end on time. That's the Carter Center way. And we're going to be talking to you about everything you really should know about except wills when it comes to estate planning. Mark and I did a webinar not too long ago, last month, and there are links to it, and we can certainly get those to you if you don't have them. We talked about wills, but there is so much more in this particular field that you really should know about and hopefully take advantage of. And so for the next hour, we're going to be talking about all those things. And just keep in mind that more than 50% of Americans over the age of 65 don't have a will. So we have no inkling what small percentage over 65 or even under 65, because we're going to be talking about the fact that even 18-year-olds should have something in place. And in all of my experience, I know of exactly one 14-year-old whose mother put an estate plan in place for her on a just in case something horrific happens. We tend to plan for our own demise. We think about it at least. But we rarely, if ever, plan to become incapacitated. And if we think, well, it might happen, and so what should I do to protect myself, make sure that my wishes are followed, and also to protect the ones I love? And so we'll be talking about that as well. I do want to give a quick shout out to Natasha Roberts. She is our assistant director who has made all the graphics here possible. And quite frankly, a lot of the words as well, because without Natasha, many of the edits, and this thing goes through lots of them, she is constantly invaluable. Ian Hamilton is our graduate assistant, and I say that with a bit of, I don't know, almost remorse, as he was offered a wonderful position today up in Boston. And so he will be leaving us shortly to seek fame and fortune in Beantown. So congratulations, Ian. We are all delighted for you. We could not possibly do what we do at the Carter Center without you folks. So we absolutely want to say thank you for it. You are great partners. Your support is ever so much appreciated. And please understand that we also greatly appreciate the fact that you would tune in to this webinar, because we have a lot to share and you could get this information from all kinds of sources. And the fact that you trust us and tune in is very flattering, quite frankly. We do hope that you will use the chat box as often as you'd like. If you have questions, we will do our very best to answer them if they happen during the presentation, and if they should come, we have a Q&A at the end. We'll leave enough time to make sure that we can do that as well. We're about to start the disclaimer because no presentation is complete without one, and for that, I'm going to turn it over to my colleague, Mark Williams, to take it from here.
How appropriate. Turn it over to the lawyer at the disclaimer. I can see if I can do the really fast speak. The information contained in this presentation, these materials are for educational purposes only. No, I promise to spare everyone. We won't do that. Thank you all, as Barry said, for joining us. Very glad to have you all along. Just want to say quickly out of the gate, again, re-emphasizing the point, this is not just for people who are older. This is really much more about the kinds of information that you'll need to protect your loved ones, and to look after the things that will have to happen if you ever can't make decisions for yourself. It can happen for people who are 18 or whatever the age of majority is in your state. So this is as much for young people as it is for older people. So just take a quick look again where we're going today. We'll talk about the powers of attorney and some important healthcare documents you need. We'll take a quick pass at trusts. And we'll go on and talk about the other remaining planning tools you can use to make things much simpler for your loved ones and that often avoid the need for attorneys and expensive legal fees.
Mark,
So,
let me jump in here for just a second,
please.
because that final point is charitable options in estate planning. And I just want to say that while everything we're talking about today applies to you and anything charitable applies to any not-for-profit, we do hope you will continue to consider the Carter Center as a primary source for that charitable gift. It means the world to us, and I wanted to make sure that I had that out right away. Mark, let me send it back to you.
Perfect. Couldn't agree more. And what an important part to differentiate the questions here that may be sort of swirling initially in your minds out there. And that's, why do I really need all of these documents? Seems like a lot, and truth be told, it is. But it's really about thinking forward to the point when, for whatever reason in your life, you may not be able to care for yourself any longer or to make decisions for yourself. And so it's a very difficult thing to think about, and it's often very difficult to talk about with our loved ones, but it's really important to do so, because if you don't make these plans, you don't get these things down in advance. Often that means a very painful and expensive trip to court where they have to get a legal guardian appointed, and that person may not be the best choice for you. So it's important to think about that as you're going forward. So as we're talking, we're talking about what is a power of attorney. You've probably heard that before. Simply, it's just an agreement you make with someone else, giving them the powers or the ability to act on your behalf. So one of the things that you need to be thinking about with those is it can't just be a verbal agreement. You definitely have to get these in writing, and that's because the rules are there to protect the person giving the power of attorney away. And we'll get more into that as we go forward. So some of the safeguards there are witness signatures, notarization. There are some important things to be thinking about in terms of vocab too. We're talking about an attorney. In fact, you'll definitely hear that as you're talking with an estate planning attorney or anyone around powers of attorney. And that's just the person that you're naming to act for you. So they can't make decisions, and no one can make decisions for you without having these powers of attorney in place. I mentioned needing to go to court to have a person named if you haven't done this already. And what I'll share is that may be a very problematic thing. I've seen it time and time again in private practice and law practice, that families often don't have resources that they need, and they're stuck waiting on this court process to play out. Meanwhile, bills are stacking up. So it's really important to get all of this done in advance. Barry, can you share with folks about the different types of powers of attorney that are out there?
Absolutely. So there's a limited power of attorney, and this is simply someone who has very specific authority, but not general authority. So say you're going out of the country for 6 months and you want someone to pay your bills, check your post office box, little things, but clearly important. You don't want the electricity turned off. You'd like to have your phone continued. You can have a limited power of attorney. You can give that to a friend, clearly someone you can trust, because this person will be able to access at least to pay bills. So we'll have check signing authority, presumably. But this is not someone who can buy and sell property for you. Then there's a different kind of limited power of attorney. It's given for a specific period of time. You could say, well, I'm giving you this power of attorney for the next week or the next month. And it's very specific what that person can or cannot do. And then there is a specific power of attorney for, say, natural disasters. You may have a property manager who needs to board up a building or do some emergency work on your behalf and would need power of attorney to do that. And then finally, there's the general power of attorney. And this is someone who has almost unlimited power on your behalf. All I can say about this is you really, really need to trust this individual. This is not somebody you just met and think, oh, he's a good guy or she's great. I can trust. There are always stories out there in the news about people who they're con artists, quite frankly, and some of them are absolutely ruthless. They get general power of attorney. They buy and sell stock. They buy and sell land and other property in your name. And there is not much that you can do about it other than end that relationship, and hopefully sooner than later. So please, if someone comes to you and says that he or she needs a general power of attorney, be absolutely certain about that before you enter into it. Mark, back to you.
That's perfect. And to say that, again, the importance of the safeguards. There are a lot of hoops that wound up having to be jumped through to make sure these meet all of the legal requirements. And so often we're talking with folks about seeing attorneys, estate planning attorneys specifically, to get this done. And as you're looking at doing a general power of attorney, it's really important to be aware of how general you really want it to be. State law often provides this very big list of powers that are given by default to a power of attorney if you are not more specific. So you can limit them if you like or expand on them. Again, so do be aware of that. And as we've talked about them, now we know that what these powers of attorney are. You might be asking yourself, well, when are they actually effective? And so that's a really important question. Most of them are immediately effective, but they don't have to be. So it's one of the things we used to talk with people about specifically for general powers of attorney. We would advise clients, hey, consider having your two of your doctors certify that you can't make decisions for yourself anymore, and have that activate the power of attorney. Really hard to get around some of that, medical consensus out there. Although we're living in a time perhaps of alternative fact, I'll leave that for another discussion. One of the other things people like to do is to have family members or loved ones make those choices for them, and that's completely fine to do that as well. So don't feel like that's something that you're stuck with. But it's also really, really important to think about this next piece. That's a durable power of attorney. I know we were talking about all these different types, and this is a simple change. It just means that this power of attorney is going to last beyond the time you pass away or you can't make decisions for yourself more permanently. So that's a really important distinction to keep in mind. You definitely want to make sure that you have a durable power of attorney, and there's a lot of reason it interacts with what happens around your will. And I wonder, Barry, if you might share more about that.
Well, if you specifically state that the durable power of attorney that you are issuing to someone will continue after you pass, then generally that power of attorney, the durable power of attorney, or any power of attorney for that matter, will end the moment you pass away. And then it's really up to whatever it is in your will, who is the executor, and that person really takes over. It's sometimes the same individual, sometimes not. And so you just need to be aware that that stipulation applies and how. By the way, none of these people who have a power of attorney, whether it's durable, flexible, whateverable, cannot change your will. They are not allowed to do that, nor can they write a will if you haven't done so. So there are some limitations even for the general power of attorney, who basically has no limitations. It's still limited in that regard.
And that's a very great point for younger people who are listening. So the point there is that if you turn 18 or up to 21, depending on your state, and you haven't put in place powers of attorney and you haven't got a will, you're not going to be able to do it. And that means that you're going to have court processes that have to play out and expense that play out, not only for your will, but also to get a guardian in place. So that's so easy to avoid. We always would tell our clients, if you've got your kids, they're going off to college, go ahead and get some basic estate planning documents in place for them. It's a worst case scenario, but it's best to have all of that covered right from the get-go.
Really is. Thanks, Mark. And finally, I want to talk about the financial power of attorney. Well, I'll ask Mark to talk about healthcare power of attorney, but the financial power of attorney, in some states, just because you have general power of attorney does not mean that you can make financial decisions on behalf of someone else. And so frequently there is something called the financial power of attorney. And it may be the same person, it may not be the same person. It may be a parent or a child or a cousin or a much trusted next door neighbor, whoever. But this is a person who can access everything you've got financially, from your retirement accounts to your stock portfolio, your bank accounts, your real estate, bond, it's everything. And so please, 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 please be careful when you make these decisions. You cannot make them in haste. You have got to have absolute trust in the person you are allowing to take this over. Otherwise, it can have devastating consequences. Having said that, Mark, you want to talk about healthcare power of attorney?
Absolutely. So it's often the case that you've heard about this described as some other term. Medical power of attorney is fairly common, but healthcare proxy tends to be one that's used as well. And I tend to find that more among the lawyers out there who may be talking to you. So if you happen to encounter that term, know they're all talking about the same thing. This is sort of a continuation on the theme of the powers of attorney. This is a person, though, who's specifically given the power to make medical decisions for you when you cannot. And so that's important to really think about from a couple of standpoints. You may or may not want to have the same person with the financial power of attorney as a healthcare power of attorney, but we'll sort of get to more on that later. The great thing about this healthcare power of attorney is you can really be specific in listing instructions for people and things that you want followed, but it's also important to build in a measure of flexibility. And we'll talk about why that is in just a moment. But suffice to say that the healthcare power of attorney works in conjunction with a couple of the other documents. So it's important that they really speak to one another. Now, you might be wondering, well, why is this one necessary in addition to all that we've discussed so far? And it's really all about the Health Insurance Portability and Accountability Act, HIPAA. So in '96, it passed a nationwide set of really, really strict privacy standards for all of your medical information. And it's critical you have this HIPAA power in the healthcare power of attorney, but go one step further. Get an actual HIPAA form for the people who you name to do this kind of medical supervision for you. Because honestly, if they don't have something that specific to hand to the doctor or to the hospital, they're going to have to go and sue the doctor or the hospital to get access to your medical records or anything that you might need in terms of billing. So again, don't let that be the case. It's way too easy to go ahead and take care of this right out of the gate. So Barry, do you mind talking about how this healthcare power of attorney works with the other healthcare document, the advanced directive for healthcare?
Yeah, by definition, the advanced directive lets the doctors know what you would like done. So heaven forbid you become incapacitated very quickly. A stroke, a car accident, a terrible fall, whatever. And you need to say ahead of time, because you won't be able to say it after that event, this is how I would like to be cared for. You might say, I want every possible known medical device used to keep me alive. You might say, I want none of that. Or you might say, I just want to be kept out of pain. I don't want to be fed. If I have to be fed through a tube, I'd rather not, but don't let me be in pain. Or you could say, yes, I don't want to be in pain. I don't want to be starved to death. So you can feed me through a tube, but that's it. And you really need that advance directive because other people are not going to be able to make it for you. And there are so many cases every single day. It's just heartbreaking where spouses, especially, or children, or heaven forbid, parents for their children or grandchildren have to make these decisions. And the doctors are saying, yes, this is what needs to happen, but there was no advance directive, and it becomes time consuming and it becomes extremely painful for those who have to make those decisions. So I encourage you, please make sure that you have someone who's named power of attorney and that you have a signed advanced directive. So, Mark, want to talk about considerations when someone's choosing a representative?
Most certainly. The key, I think you guys have heard us harp on this a few times already, and we're just going to go ahead and keep strumming away on the harp here. Trust is probably the very single most important factor here that you could use when choosing to have people who are exercising these powers on your behalf. So one of the other things that we always really tried to counsel people on in law practice was that, you really want people who are going to be around for a long time. Most people use these as sort of planning for in our older age, and that's exactly what we should be thinking about, right? So if that's the case, we get older, we need help, we generally want someone younger looking after us. But always name multiple backups, because as Barry mentioned, sometimes the decisions around care can be so difficult for the ones who have to make them. You want to name other people who can be there to step in if it's something that your loved ones just can't do. So to that end, I've seen this play out a couple of times, and some of you probably will remember the very famous case of Terry Schiavo. You need to be specific with this and have this out, because it may be that you have very specific wishes and your family would disagree, and unless it's spelled out, it could lead to litigation, lots of difficulty and hard feelings between family members. So please don't leave that to them. It's important to have people who will take care of your wishes and do what you've asked them to, no matter. So we always advise people, if you're naming more than one agent, make sure you name an odd number. You never want to have to go to court and ask a judge to break a tie. It's not going to come out the way anybody wants it to. And think about the opportunity or to provide compensation for these people who are going to be standing there and making sure you get the care that you need when you can't. Most people, loved ones, friends, family, don't want any kind of compensation, but it's fair to think about it. They're going to spend a lot of time looking after you and taking care of your affairs. So just something to think about as you're out there having these discussions. So, here we are to one of my favorite topics, and I'm going to go ahead and give it away to you, Barry.
Mark, it's terribly generous of you. Trusts. We've talked so far this afternoon about documents that you're going to need or should have, or at least know about. When we talk about trusts, people say, I've heard about these things. I'm not wealthy. I really don't need a trust. You can create what's called a revocable trust. We'll get into that another time, but you can create one of these that will actually, you can put everything you own into the trust so that when you pass, there's nothing to go to probate. There's nothing to go to court, because the trust owns everything you had, your house, your car, retirement account. You can put whatever you want into it. And then your will dictates how the trust will be dissolved after you pass, with no one to need to go to court. Generally, while you are alive, you are the trustee of your trust. So you are, yes, you're putting your house and car and valuables into this trust, but you are the trustee. And so you make all the decisions. You can buy things and put them in the trust. You can sell things from the trust, not a problem. But then it goes a little bit further. And trusts can be created during your lifetime or after you pass away. And it can be pretty much just that easy. It does require a special document. And I just want to let you know that in this particular instance, even if you have not used a trust and estates attorney up until now, you really need a trust and estates attorney to handle the establishment of a trust for you so that you're absolutely positive that it is keeping within all the laws of the state you are in. I liken it this way. If suddenly you end up with horrible chest pain and you're clutching your chest, which for those of you who don't know, if you're clutching your chest, it's called the Levine sign, because Dr. Levine picked it up, and when you're clutching your chest, it's called a positive Levine sign. You didn't come in for this, but I gave it to you nonetheless. So, you're raced off to the hospital and you're given two choices. You can have a cardiologist treat you, or you can have a podiatrist treat you. Now, who would you choose? Well, of course you would choose the cardiologist because that doctor specializes in the heart. When you go to create a trust that's going to hold your worldly belongings, you may have a wonderful friend from high school who went on to become a real estate attorney, but that person does not understand trusts any more than a trust attorney would necessarily understand real estate law. So please find someone, ask your friends, ask around. Don't just go by what you hear on the internet. Ask people. They'll tell you who they've used or who they trust to create such a thing. And it's absolutely worth every moment that you spend doing it.
Well, in particular, when you factor in the fact that there are times that tax issues and asset protection issues will drive the planning. So it's one of those things, again, you really want to make sure you have professional advice.
Always. And finally, we're going to be talking about trusts in great detail on our next webinar in August. You can come back here on August 20th at 2 p.m. That's Eastern Daylight Time. Or on the 25th, we will repeat it. Both will be live, August 25th at 5 p.m. So we would encourage you, please, to consider that, because the conversation about trusts is so in-depth that we really could not do justice to it within the time constraints of this particular webinar. So the next one will be dedicated to that solely. Mark, back to you.
Absolutely. Yes, we really want to take the time to get this information out to you guys so that you have it when you decide to start having those conversations with estate planners. We want you to feel comfortable. So again, by all means, let us know if we can help out personally in between. You can always reach Barry and I by phone and email, but we'd be happy to talk to you more specifically about how trusts might fit with your situation. Again, sort of coach you up for an office meeting if you'd care for one. But we should talk about how a trust can help, right? So that's the real part of this, is finding out what they are. They are really powerful tools for protecting property, particularly for people who may have, say, high-risk jobs. You hear often that doctors, surgeons in particular, are sort of at risk for lawsuits if there are any mistakes. And it's not the only occupation. You could have someone who works doing explosives work. We actually had a client that did that once, and we put a trust together for his family. So those are important things to keep in mind, but also it's about keeping what's there safe for the people who inherit it. So if you've got a family member who just spends too much money, or say they're too young to be able to manage money or a family business, trust is the best possible way to be able to make sure that everything is managed properly until they are ready. Also, I mentioned tax issues can drive trusts. For certain, saving on taxes can be a big motivator for all of this, but also a lot of people like to use trusts specifically to handle their charitable planning, and we'll talk about that much more specifically next time. But if you're interested in the meantime, we're always happy to provide sample language you might use in your trust. You can use it to talk with your attorney about how it fits for you. So there are some other important things to keep in mind, right? As we talk about estate planning, wills, and powers of attorney and things, it's really important about being strategic and planning for all of these things down the road. You don't want to have the complexity and the time wasting of the courts process playing out there. So again, that estate plan, if it's good, it's going to reduce complexity and expense. And again, never wanting to bring this up, but having to be realistic. The possibility of lawsuits among family members really can be kept to a minimum if you're doing good planning work up front. So with that said, most people also look at this and say, well, the whole reason why we do this estate planning is to get rid of the probate process. And we're about to find out why. So this is the process, whether you have a will or you don't. After you pass away, you have to go to court. And you have to get a judge to approve any kind of giving of assets to heirs. So it doesn't matter if you have a will or you don't, and it's a process. Let's take a look at this process. So generally, it's only about 5 steps, but they take months and months to play out. Step 1 is always filing a petition and paying money to the court. As you move past that, you got to bring everybody into the court. The person who is taking care of all of your affairs has to be sworn in before a judge. There have to be witnesses who come in who say that they saw you sign your will and that they were the ones who signed as witnesses. And it's a production and a process. It's expensive to do that. After you've gotten the approval from the judge to go ahead and set up the estate, then the real work actually begins. Whoever's doing that has to figure out all of your property. They have to figure out all of the debts that you have. They have to notify your creditors, usually through the newspaper and often now through online channels. As they get all of that information in, they've got to sort those out. Hey, meanwhile, they're stuck filing taxes. And anyway, all of this is to say that if you don't want your family having to deal with this, or at least dealing with it as little as possible, you can do that with a good estate plan. So, Barry, would you mind sharing how this can really simplify things?
Yes, because if you have everything in a trust, there is no probate. It's just that simple. And the executor of your will need to follow your directives. But nothing ends up in court because everything is then owned by the trust, and the trust will portion out its holdings as you have so stipulated. Then there are other things to consider when you are planning your estate. Perhaps the most important one is your retirement accounts, because what you end up doing with those retirement accounts could actually end up costing the loved ones you leave. If you leave it to a spouse, there's no issue. It's 100%. There's no tax. If you leave it to anyone other than a spouse, under most circumstances, your retirement accounts can become quite problematic. That was not the case until January 1st of 2020. But since January 1st of 2020, those laws have changed considerably. We did send you a copy of this PowerPoint, and if you get on to slide 30 and you click on that, it will take you to our first webinar, which talked very specifically and at some great length to let you know what the advantages and disadvantages are. Suffice to say for right now that retirement accounts are best used as gifts if you want to provide charitable gifts to the Carter Center, or for that matter, any other organization, nonprofit organization, you can do that, and there'll be no taxes taken out. While if you end up giving it to an individual, there are considerable taxes, unless it's a spouse. There will be considerable taxes that have to come out of that, and there are other estate planning tools like life insurance. We like life insurance because there's this weird thing in the law that says life insurance proceeds are not taxable. So if you have a $1 million life insurance policy and you name someone as the beneficiary, that person will collect $1 million when you pass, and there will be no tax on that. You can set these things up pretty easily. It is a great way to protect the ones you love, and regardless of what's in your will or debts or in your trust or anything else. And if you're concerned about children being too young or perhaps irresponsible to handle that kind of money, you can set it up that there's a trust that ultimately holds the money and then parses it out to your loved ones as you saw fit during easier and more profitable times. Then there are commercial annuities, and there are what we're trying to tell you here is you have all kinds of options, and understanding your estate planning tools, whether they are commercial annuities or charitable gift annuities, whether they are trusts or insurance policies, they are all very important for you to understand so that you can make educated decisions. The worst thing that can happen is someone coming in and saying, well, you need this, that, and the other. And you're, well, okay, you sound like you really know what you're doing. I guess I'll follow your advice. And that can lead to very bad times. Mark, back to you.
Absolutely. And to just emphasize again, the real goal here is getting folks comfortable and familiar with all of the tools that are out there, the options, and to have an understanding of how many of them are going to require them to go to court. So thanks for hanging on through all of this. I know it's gotten to be a little bit of dense information, but again, very important. So as we've talked about some of these different types of beneficiary designations for insurance policies and for the annuities and even with the trusts, that's one of the things that also makes a lot of sense to think about planning with beneficiary designation. So one thing that's similar to that is a transfer on death bank account or TOD bank account. These also exist for stock accounts, brokerage accounts, basically. And they're very, very important to have for one of the major reasons that I mentioned before. If something happens to you and these are all tied up basically in court and your family is having to wait to access them, it can be very difficult. So by using a TOD or a transfer on death account, you make sure that right away the people have access to all the money that's there and they get what they need. So very important to have and to use effectively. Now, this is something though that is not as common, and I would certainly suggest thinking about talking to an attorney about it. Transfer on death deeds for real estate. Now, there are certain states where this is allowed and a few others where it's not, but the great thing is for those states where it is allowed, you don't have to worry about going to court and going through the whole process of retitling your real estate and doing all of the other hoops that come along with probate. It's a very, very simple way to provide a family home or a vacation home if your property's in the right place to your loved ones. Again, no need for attorneys, generally speaking. Some of the states have forms that are available for this. So, but be aware that because these can do a lot of damage in terms of transferring away something like your marital home or vacation home, they're often very, very regulated by state law, and generally speaking, best to have an attorney help you with this. So on that note, We talk about these specifically because we want you to know, again, it's a way to avoid probate and to simplify things for your loved ones. Please talk about how you could use these transfer on death accounts and designations to support your loved ones. Barry, one of my other favorite topics, would you mind taking us forward with a discussion of the importance of step up?
Step up.
Now, sorry, I was going to say, this is why I asked. Barry does this much better than I do. I tend to go off into inexplicable strings of legalese and no one stays with us. So I just wanted to say that I need Barry to do this. This is a really important planning tool. It's sort of a democratization of one of the wealthy's favorite planning strategies. So with that, I'm going to go ahead and ask Barry, please pick it up again.
Mark, what the heck did you just say?
See?
All right, enough. Step up basis. Let me give you an example. Let's say you own a home and you're going to give that home to your one and only son when you pass. If you were to give that home to your son the day before you pass, then your son ends up getting that home at what you paid for it. Let's say you paid $100,000 for the house, and it's actually worth $1 million now. Well, because you gave it during your lifetime, your son ends up getting that house and ultimately will owe tax on $900,000. If, on the other hand, you were to will that house as part of your will to your son, it ends up that $1 million that it was worth on the day you die. Well, that's what your son inherits it at $1 million. He could turn around, sell it for $1 million and pay absolutely no tax. And so the step up basis is critical. Now, please understand, step up basis is in full view for all spouses. It's automatic. So if your spouse inherits your business or your vacation home or stock portfolio, whatever your spouse may ultimately inherit from you, is entitled to the step up basis. So you're not putting a great deal of tax, you're not putting any tax for that matter, on your spouse. But for anyone else, it is critically important that that you consider this step up basis to avoid, in some cases, millions and millions and millions of dollars in taxes that just did not have to be paid. And there are all kinds of horror stories. We won't bore you with them right now, but I would love to bore you with them another time. And on that, Mark, I wonder if you want to take it into charitable estate planning.
Absolutely. So we've covered a lot of ground, and I'll try to wrap this up pretty well. It's so easy. If you're thinking about including the Carter Center or other organizations you support in your estate plans, it's so easy to do that in ways that don't require a will and in ways that don't require probate. Again, we talked about these beneficiary designations and insurance policies and annuities, same with retirement accounts. And we've also talked about the transfer on death style accounts that are out there, again, similar to a beneficiary designation. All of those are easy. All of those can be done generally without an attorney if you're just really averse to doing that. And again, very, very easy in these situations to name charity as a beneficiary. One of the things Barry and I like to talk with people about when they are considering gifts like this is, okay, don't necessarily specify a set dollar amount. Instead, think about making a gift in terms of a percentage, because let's say, for example, with a transfer on death account for a bank account, you say, I give 100,000 of this to the Carter Center and the rest to family. If something happened and you had expenses that meant there was less than 100,000 in that account, you wouldn't want that to impact your family members, your loved ones at all. So it just builds in more flexibility for you as you're working on your estate plan. And again, it's great because it can grow and flex with you. Anytime you're thinking about making some of these gifts, or if Barry and I can be of help by providing sample language, of course, always feel free to reach out to us. We'll be happy to do that anytime. It's always good to see you when we can't really see you and talk to you. So, Barry, I know we've got just a little bit of time left. I wonder if you might pick it up here for us.
Yeah, I definitely want to talk about retirement funds. These are very, as I said, after January 1st of 2020, very heavily taxed. But you can make provisions in your will or in your trust that the assets from your retirement account will create either a charitable gift annuity or a charitable remainder trust, using the proceeds from those accounts specifically to pay essentially dividends to those you leave behind for whatever. You want to help them, you just don't necessarily want to saddle them with very high taxes. And you'd also like to help a charity, perhaps the Carter Center. And so you can say that whatever's left in my IRA, I want to create a charitable gift annuity for my son and daughter. And then that will be the executor of your estate will transfer those monies to the Carter Center with that proviso. We will create that annuity. If you would like to know more about annuities, especially charitable gift annuities and charitable remainder trusts, we have discussed that a little bit, and you can click on the link on slide number 40, or even better, you can come back on the 20th and 25th of August, or the 20th or 25th of August, and you will hear us talk about at great length these trusts, as well as revocable and irrevocable. Revocable meaning you can change it anytime you want. A revocable trust, by the way, becomes irrevocable. You cannot change it the moment someone passes. So if it's the Barry Nicholsberg Revocable Trust, that becomes an irrevocable trust the moment I pass. And then the executor of my estate would then take over and make sure the distribution of that trust was how I intended it to be, by spelling it out in my will. And that those trusts can be established during lifetime, or they can be established immediately as you pass. The moment you pass, those trusts then can be established if you have taken the time to set them up that way. And so there are all kinds of charitable trusts and planning strategies that we will be discussing, and I do hope you will be back with us in August when we do that. Mark?
Well, here we are, folks, at the end. Thank you so much for staying with us. Barry and I are always happy to work with you. Anytime you'd like to have a conversation about this, we can talk more about terms maybe that were hard to understand, or if we move too quickly through some of this. But also, if you're really thinking about making the step and you want to talk to us about specifically how this might affect a tax situation, and you'd like us to talk with your attorneys or your financial advisors, we're always happy to do that too. It's a privilege to be able to serve you. And if you would like to reach us, here on slide 43 in the materials that you've got, just click on Barry's card or my card, and it'll immediately launch an email to us from your computer. Or feel free to use the telephone numbers that are there. Even though we're not in the office, we are still getting phone calls on our cell phones. So with that, thank you very much, and we'll open it up for question and answers.
So do we have questions? Because I've got a couple here from the last one we did. If we have time, we'll get to them, but I certainly want to address the questions that folks who are watching right now may have had. Mark, anything there?
Yes, actually. So we've got a couple of different questions here. Someone mentioned they listened to the presentation on July 16th, 78 years old, single woman with 3 very productive adult children. Way to go, all married. I have never had appropriate advice. 2 valid wills, obsolete with 2 different attorneys. but have a living will for my middle son and his wife. My middle son and wife live in the same homestead, different living areas, and the will has been the rub. 3 children, family is independent. I have been, not by family, questioned dramatically why I did the living will, and there are many belongings, contracts, etc. I'll be given to family down the way. Any constructive advice you might have regarding dividing my estate, that would be helpful. And reworking the will and would seek out the right type. I'd love, Nancy, I see there that you've left the name. I wonder if I might ask you to send me an email about that one. I'd really like to take the time to answer that one the way that it deserves. But suffice to say, I mean, it sounds like a good situation with a few wrinkles that could be ironed out. So I apologize. I know that's not necessarily the answer you're looking for, but I promise to work with you on it if you do. Okay. So I've got another question here about trusts, and also whether or not the property in a trust would qualify for a step-up basis. So you get an A and a gold star for this question. What I'll say is this is an incredibly important question that has a very important distinction. So yes, but you have to have the right trust. So anything that is in a revocable trust, the law basically looks at it as if that was still yours up until the time that you pass away, because you could always go back in and take everything out of the trust and shut the trust down if you like. So anything that passes through the trust to your loved ones, your heirs, that technically qualifies for a step up in basis, gets that great tax treatment. But if you have an irrevocable trust, and we'll talk more about why you might have those in the next webinar, but that would be a different situation. You're often planning to not have step-up basis because of the other protections offered by that kind of trust. So,
any other questions, Mark?
Let's see. So, I am not seeing any other questions right at the moment.
Let me pose this one, which was asked last time around. What is a no contest clause?
So a no contest clause is something that you'll typically see a little bit more frequently when people are talking about a will. And so the no contest clause is really just a tool that you'll use in your estate plan to say, okay, anyone who is unhappy with what they're getting under the will, and they challenge the will by going to court, then they're basically written out of the will. They get nothing. This same kind of clause can be used in a trust. So that is a very, very helpful planning tool, something that it can be helpful if you anticipate there being family conflicts, and we've seen plenty of people use them successfully. Some states now are sort of changing how enforceable they will make these clauses when there are valid reasons for them. But just to say that it gets to be very sticky and difficult, it's best to try to avoid that at all costs. Barry, I do have another question here that I'd like to touch on. Someone's asked if it's a conflict of interest to consult an attorney about transfer on death deeds. Doesn't using the form negate the need for the attorney who'd otherwise include the property in a trust? So the importance of consulting an attorney about the transfer on death deed is really more about the importance of having the conversation to know whether or not it is actually legal in your state to use the tool. I say that because it can be difficult to find this information if you don't know specifically where to look. But as for the issue of fees and the transferal of property back and forth between a trust, I would say again, I don't know that I feel that's necessarily a conflict of interest, because all the attorney is probably trying to help you do is to learn or to make the most effective, tax efficient and legally effective transfers into the trust or whatever the estate plan is. Regardless of fees. And I think one of the other things you'd notice too in talking with folks, a lot of times there's a flat fee that goes into estate planning work rather than an hourly. So the attorney usually has no real incentive to sort of look at this on an hourly rate or as a forfeiture of any kind of fees. These folks, anytime you engage an attorney, they owe you a duty of loyalty and confidentiality and of competent advice. So my answer to that is a long one, but I would say, based on how I've read the question, I think that that's probably not as big of an issue, though you couldn't rule it out.
Is that it, Mark, on the questions?
Let's see, did I get any new ones? I am not seeing any new questions.
And what I'd like to say is, first of all, I would like to thank Mark for making all of this possible with me. I greatly appreciate that. Natasha Roberts, thank you again for your graphic work and all of your editing work. And Ian Hamilton, as our graduate assistant, we will miss you dearly when you go off into the real world and wish you every possible success. Ladies and gentlemen, these are truly insane times that none of us have even imagined, let alone had to live through before. Everything is more difficult than it's been. Many of us who are accustomed to traveling have not traveled since March. Many have not hardly left their house since March. We are all praying that those who end up with COVID-19 are healed quickly and fully. And we pray for those who have passed and their families in this horrific, horrific virus. Given that state and times, that you would take an hour out of your lives to spend them with us right here, right now, is as flattering and as great an honor as you could provide to us. Again, we thank you so much for your support of the Carter Center. If you have any other questions about any estate planning matter that we've discussed today or in previous webinars, do not hesitate to send us an email or call us. Our cards are on, I believe, slide 40, and we will do our very best to answer them as completely as we possibly can. With that, for my colleagues, for the Carter Center, for myself, I wish you all Godspeed. Bye-bye.